Hi, everybody. I'm Mike Rappaport, and I'm the director of the Center for the Study of Constitutional Originalism. And I'd like to welcome everybody to the 16th annual Hugh and Hazel Foundation Works in Progress Conference. Every year at the beginning of the conference, I use this time to highlight what I regard as the most important events concerning originalism in the past year. And this year, I think, was another significant one for originalism. In my view, most of the important events happened at the Supreme Court. Perhaps the most important Supreme Court originalist decision involves statutory originalism, the Loper-Bright versus Raimondo case, which held that the Administrative Procedure Act did not allow for Chevron deference. In my view, Chief Justice Roberts wrote a persuasive originalist opinion showing that the APA required courts to decide legal questions without Chevron deference. I rarely find Roberts' opinions persuasive originalism, but this was an exception. What makes Loper-Bright especially significant is that it's likely to have a substantial impact on a large number of cases. Agencies will have less power to implement their policy agendas and less power to engage in the wild and disoriented swings of policy that result when one administration replaces another. Loper-Bright is also significant, I think, because it may be part of a trend of originalist decisions that constrain the administrative state. Another decision from the past year doing so was SEC versus Jacarsi, which held that a fraud action for civil penalties needed to be decided by a jury in an Article III court and couldn't be decided in an agency. While the court has decided some originalist cases against the administrative state, it has also decided in favor of administrative agencies based on originalism. In CFPB versus Community Financial Services Association, a permanent funding provision for the CFPB, which allowed the agency to request an amount of funds from the Federal Reserve up to a maximum amount, was challenged as violating the Appropriations Clause. But Justice Thomas's opinion for the court relied upon originalist history to show that the CFPB appropriation conforms to appropriations at the time of the Constitution. This decision shows principle on the part of the originalists who joined it. Even though holding the appropriation unconstitutional would have limited agency power, the decision held it constitutional. Moreover, it seems likely that Thomas would have preferred on political grounds for the CFPB funding to be struck down, but he followed originalism to allow it. Another important development involves how the court reached originalist decisions while minimizing their disruptive effect on non-originalist precedent. In some cases, the court cut back or refused to extend non-originalist precedent without overturning it. For example, in Jacarsi, the court held that a fraud action for civil penalties needed to be decided by an Article III court, while not overturning but merely distinguishing the widely criticized case of Atlas Roofing. Similarly, in Grants Pass, the court held that prohibiting homeless people from camping did not constitute cruel and unusual punishment, while not overturning but merely distinguishing the outlier Warren Court case of Robinson versus California. Even more significantly, I think, the court overturned non-originalist precedent without causing undue disruption in Loper-Bright, where the court applied its ruling to future cases but not to existing precedents that had applied Chevron. This is a type of prospective overruling that can promote originalism without imposing significant reliance costs. An extraordinary event occurred in the Rahimi case, where several of the originalist justices debated originalist methodology. While many of the justices made significant statements, I want to highlight here the differing positions of Justice Barrett and Justice Kavanaugh. Kavanaugh argued that when the text is unclear, there are only two ways to resolve it: history or policy, and he favored history. Given this position, it's not surprising that he not only favored considering history at the time of enactment, but also for many years later as the best way of discerning the original meaning. By contrast, Barrett argued, much more persuasively in my view, that it is only the original history from close to the period of the enactment, that provides evidence of the original meaning. While Kavanaugh cites Scalia for his position, even assuming Scalia meant what Kavanaugh says he meant, even Scalia can nod. Barrett also argues, although not in response to Kavanaugh, that even originalist history is not limited merely to precise, narrow historical examples. Instead, she writes that historical regulations reveal a principle, not a mold, and pulling principle from precedent, whether case law or history, is a standard feature of legal reasoning, even though reasonable minds sometimes disagree about how broad or narrow the controlling principle should be. I agree with Barrett, and I might add that the original history is seldom entirely silent on a matter, and therefore one can often discern a more likely meaning, even if it is not certain. Thus, Kavanaugh's dilemma between history and policy when the original history is silent is less likely to occur. But Kavanaugh does have some important points. While late practice may not have originalist force, it was treated both before and after the Constitution as having some legal force, analogously to judicial precedent. And Kavanaugh, I think, is on the mark when he writes that when determining how broadly or narrowly to read a precedent, a court will often consider how the precedent squares with the Constitution's text and history. Some commentators, such as Josh Blackman, have argued that the current Supreme Court is a 3-3-3 court. It has 3 conservatives, Thomas, Alito, and Gorsuch, 3 moderates, Barrett, Kavanaugh, and Roberts, and 3 progressives. While this may be the correct way to analyze political divisions on the court, there is a different 3-3-3 court based on originalism. In my view, the 3 most consistent originalists are Thomas, Gorsuch, and Barrett, and the 3 originalist moderates are Kavanaugh, Alito, and Roberts. The big difference is that Alito should be grouped among the most conservative justices, but Barrett should be grouped among the most originalist justices. While I don't agree with everything that Barrett does or says, I think she's a careful thinker who makes a strong effort to follow the original meaning. She may or may not be a moderate politically, but her actions appear, to me at least, to be largely the result of originalist principles. By contrast, I would classify Justice Alito to be less of a consistent originalist. While he has come to classify himself as an originalist in recent years, his strong views on precedent and his practical originalism do not exhibit as consistent a commitment to originalism as Barrett. While there have been many important originalist victories, I also believe there have been some significant originalist defeats. I would place the 2 Trump cases, the immunity case and the disqualification case, in that category, even though the originalists on the court largely voted for these non-originalist decisions. In Trump versus the United States, the Supreme Court immunized official presidential actions from criminal prosecution and defined that immunity very broadly. In my view, much of this immunity was just made up, as there's nothing in the Constitution that grants it. The Constitution does allow presidents, former presidents, and presidential candidates to be protected, but it requires Congress to pass a law doing so. Why did the Supreme Court originalists reach this result? I cannot say for sure, but my guess, and here I largely agree with Will Bode, is that the court was attempting to stop what it saw as serious partisan abuses of prosecutorial power. One may sympathize with this sentiment while recognizing that originalism does not justify it, even if many non-originalist theories might allow it. In Trump versus Anderson, the Supreme Court announced that Section 3 of the 14th Amendment could only be enforced by Congress. Again, this just seemed made up. The per curiam opinion somehow read the states out of the process of electing a president, which is clearly contrary to the Constitution's plan. In my view, whatever one thinks of Trump's problematic actions on January 6th, they do not constitute engaging in an insurrection. The court should have decided the case on that basis. But my guess is that the court wanted to avoid deciding the case based on such a politically charged reason and preferred a position that would be joined in part by all 9 justices. In the last year, there's also been 2 important books published on originalism. There's Jack Balkin's Memory and Authority, which further develops his unorthodox originalism, and Jonathan Genapp's Against Constitutional Originalism, which criticizes originalism from a historian's perspective. These are important books. While I don't agree with much of what they say, they should be discussed and debated. And these books are a sign of the importance of originalism. They show that the debates over originalism remain fresh and vibrant, and they are likely to contribute to its continued development. Finally, although many of you may have missed it, Donald Trump was reelected in November. In his first term of office, Trump appointed more originalist judges than any other modern president. 3 originalist justices and many originalist circuit court and district court judges. Had Trump not won the presidency in 2016, originalism would be in a much weaker position on the judiciary, at least. Trump's reelection then might possibly lead to further growth in the number of originalist judges. Of course, nothing is certain, as the second Trump administration is likely to have different selection procedures and could conceivably choose conservative non-originalists.